Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Starting with two important updates from the Supreme Court's bench of Justices Sanjeev Khanna and Dipankar Datta. The bench today heard the petitions filed by Delhi Chief Minister Arvind Kejriwal and former Chief Minister of Jharkhand Hemant Soren, both challenging their arrest by the Enforcement Directorate. While arguing Delhi Chief Minister Arvind Kejriwal's plea in the Delhi liquor policy case, senior advocate Dr. Abhishek Manu Singhvi alleged that the arrest was unjustified. He presented a list of dates to the court asserting that Kejriwal's arrest was unnecessary as none of the documents filed from August 2022 until the arrest linked him to the alleged scam, that he was not named in the CBI FIR or the ED ECIR. Singhvi claimed that Kejriwal's arrest occurred during the implementation of Model Code of Conduct for the Lok Sabha elections, despite there being no new evidence or valid reasons for the agency to take such action. Answering the bench's query, Singhvi informed that Kejriwal had not filed a bail application but had instead submitted a writ petition contesting the arrest, citing its illegality under Section 19 of the PMLA as the reason for the wider scope of the petition. Singhvi emphasized that Kejriwal's arrest followed the announcement of Lok Sabha elections despite the alleged incriminating statement were made in July last year. He then questioned as to why did ED let a guilty chief minister roam free for months and only arrested him in March 2024. The hearing in this matter will continue tomorrow. Also today, the same bench issued notice on a petition filed by former Jharkhand Chief Minister Hemant Soren challenging his arrest by the Enforcement Directorate. As you know, Soren was arrested by ED in January in connection with an alleged land scam in Jharkhand. He is accused of being the primary beneficiary of the fraudulently acquired land. After his arrest, he had approached the Supreme Court, but the court had asked him to approach the High Court instead. Accordingly, he moved the Jharkhand High Court, which heard him on the issue of Enforcement Directorate's arrest and reserved the verdict on 28th February this year. He has filed the present SLP, citing the delay by the High Court in pronouncing the verdict. Today, his counsel, Senior Advocate Kapil Sibal, told the bench that there was nothing showing Soren's involvement, even if ED's affidavit was accepted entirely and that he was seeking interim bail. The bench issued notice and posted the matter in the week commencing from 6th May. The court also said that in the meantime, it shall be open to the Jharkhand High Court to pronounce the judgment. Coming to an update from the Delhi High Court, which dismissed a plea today seeking to disqualify Prime Minister Narendra Modi for 6 years from contesting elections. This was sought against PM Modi for allegedly seeking votes for the Bharatiya Janata Party in the name of Hindu and Sikh deities and places of worship. The petition was filed by a lawyer who said that the Prime Minister in his speech had said that he constructed the Ram Temple, developed Kartarpur Sahib corridor and brought back the copies of Guru Granth Sahib from Afghanistan. The plea submitted that it was expedient in the interest of fair elections on the part of Election Commission of India to take immediate action against the Prime Minister. It was his case that he filed a complaint earlier this month before the Election Commission of India to register an FIR against PM Modi and to disqualify him from elections, but no action had been taken by the ECI in the matter. However, Justice Sachin Datta today observed that the petition was thoroughly misconceived as the petitioner had presupposed that there had been a violation of the Code of Conduct. It was observed that the court could not direct the Election Commission to take a particular view on any complaint. The court also recorded the submission made by the Election Commission of India that it will look into the petitioner's complaint in accordance with the law. The Apex Court today adjourned until July an SLP filed by the state of West Bengal against Calcutta High Court's judgment directing the CBI to investigate allegations of land grabbing and sexual assault in Sandeshkhali, West Bengal. If you recall that the Calcutta High Court had taken a suo motu cognizance of newspaper reports on alleged sexual harassment of women living in Sandeshkhali and tribal lands that had been forcibly taken over. Allegedly, these instances took place under the watch of former Pradhan Shah Jahan Sheikh and his workers. This was preceded by the assault on ED officers, allegedly by followers of Sheikh. The court had transferred the investigation regarding this attack on the Enforcement Directorate officers to the CBI, which was affirmed by the Supreme Court as well. The matter was today adjourned by the bench of Justices B.R. Gawai and Sandeep Mehta after senior advocate Abhishek Manu Singhvi, who appeared for the state, requested the court to take up the matter after a couple of weeks. He submitted that there was some important information that could not be collected to be filed with the present SLP. Singhvi also assured the court that the pendency of the petition would not be used as a ground for any purposes. Shah Jahan Sheikh, a now suspended member of the Trinamool Congress, is the main accused in the case. After the pronouncement of the order today, Justice Gawai questioned as to why should the state come as a petitioner for protecting the interests of some private individual. The Supreme Court bench comprising Chief Justice of India D.Y. Chandrachud, Justices J.B. Pardewala and Manoj Mishra today issued notice on a writ petition seeking a declaration that a person who was born a Muslim but ceased to be a believer would not be governed by the Sharia law. The petition has been filed by a Kerala-based woman who stated that she was not a believer and hence should be governed by the Indian Succession Act with respect to inheritance instead of the Muslim personal law. She is the president of an organization of ex-Muslims. Advocate Prashant Padmanabhan for the petitioner told the court that as per the personal law, a Muslim person cannot bequeath more than 1/3 of his properties by way of will. He pointed out that the petitioner's father is also a non-believer and that Muslim women are entitled to only 1/3 of the share of male heirs. He stated that the petitioner here was in a peculiar situation. Her father could not bequeath more than 1/3 of the property to her. The remaining 2/3 will go to her brother who was suffering from Down syndrome. The petitioner also had a daughter, but after her death, the entire property will not go to her daughter as her father's brother will also get a claim. Initially, the bench expressed reservations at the petitioner's proposition. The CJI pointed out that as per the Sharia Act, a person has to make a specific declaration to be governed by it. And the Indian Succession Act clearly states that the Act will not apply to Muslims. Therefore, a void may be created if a declaration as sought by the petitioner was granted. The bench also wondered how could the court give a declaration regarding the non-applicability of personal law to a person under Article 32 of the Constitution when the petitioner has not challenged any statutory provision. But after elaborate discussions, it decided to issue notice to the Union of India and the state of Kerala on the petition, terming it an important issue. The matter will now be posted in the second week of July. Stay tuned. The Supreme Court has today rejected the petition to postpone the CA exams held by Institute of Chartered Accountants of India in view of Lok Sabha elections. The Chartered Accountant exams for immediate and final level are scheduled on 8th and the 14th May. Also, the elections for the 18th Lok Sabha are scheduled on 7th and 13th of May this year. Senior advocate Madhvi Devan for the petitioners submitted that it would be difficult for students from interior regions to reach the exam centers the next day after exercising their franchise. A bench comprising Chief Justice of India D.Y. Chandrachud, Justice J.B. Pardewala and Justice Manoj Mishra heard the matter today. But the court rejected the petition, saying that postponing the exams one day after the phase-wise polling, as suggested by the petitioners, would cause severe hardship to several students. It noted that over 4.3 lakh students have registered for the exams and postponing the dates will cause grave hardship. The bench also noted that a total of 591 exam centers have been arranged across India and that no exams are scheduled on the polling dates. The court also accepted the ICAI's submission that giving opt-out options would prejudice those students who take all papers in a single attempt. The Supreme Court bench of Justices Sanjeev Khanna and Dipankar Datta today extended till September the stay on trial against Tamil Nadu BJP leader K. Annamalai over his alleged remarks against a Christian missionary non-profit. To give you a short background here, Annamalai in a YouTube interview had allegedly stated that a Christian missionary NGO was responsible for seeking a ban on firecrackers. His statement drew significant attention and controversy. Following the circulation of video clippings from the interview on social media, a complaint was filed by an environmentalist expressing concerns that the remarks could incite hatred between communities. Challenging the summons and the entire proceedings in this regard, Annamalai contended that his speeches were expressions of anguish and not intended to promote communal discord. This he contended before the High Court. He highlighted the timing of the complaint filed approximately 400 days after the interview, during which no untoward incident had occurred based on his speech. The Madras High Court had dismissed his petition and emphasized the psychological impact of his statements, which were deemed to have communal undertones. It also noted that the intent to create hatred towards a particular religion was evident in his statements, leading to a prima facie conclusion against him. Against the High Court's order, he has approached the Supreme Court in a special leave petition. The matter was today adjourned to 9th September. Stay tuned. Coming to an update on the petition filed by the Karnataka government against the Union of India for drought relief funds. Previously, the Attorney General had informed that the Election Commission had given clearance to the centre to deal with the issue. Following this, last week, the centre announced the release of 3,454 crores as drought relief as against 18,171 crores sought by the state. The amount was different for divisions such as crop loss input subsidy, gratuitous relief to families whose livelihood has been seriously affected, for addressing a shortage of drinking water relief, and towards cattle care. Today, Senior Advocate Kapil Sibal for Karnataka mentioned that there was an inspection by the Interministerial Central Team. Thereafter, he submitted that out of the Rs 4663 crore claim, the relief of 3454 crore had been given, and the claim towards gratuitous relief to families had not even been addressed. He further stressed that the Interministerial Central Team, after it went to the state, had submitted its report to the subcommittee, which was then submitted to the Home Ministry for decision making. However, the report was not with the state. Sibal requested a direction that the same report must be placed before the court. After this, the court asked Union to submit the report of the team. The matter was thus adjourned to next Monday. A division bench comprising Acting Chief Justice Manmohan and Justice Manmeet Preetham Singh Arora of the Delhi High Court today dealt with a PIL filed by NGO Social Jurist, arguing that students in the MCD schools are being deprived of statutory benefits like uniform, writing material, notebooks, etc. in the capital. The plea sought a direction upon the MCD to ensure that all the students have operational bank accounts and that benefits be provided to them through bearer checks till these accounts are opened. Earlier, the court was informed by the MCD Commissioner that only the Standing Committee has the power to award contracts worth more than 5 crore rupees. Last week, the Delhi government had told the court that delegation of power can be done only with the consent of the Chief Minister, who is presently in judicial custody. The High Court today said that the decision of Arvind Kejriwal to continue to hold the position of Chief Minister despite his arrest is his personal decision. But his non-availability cannot come in the way of young children studying in MCD schools from receiving their free textbooks, writing material and uniform. The bench directed the MCD Commissioner to incur the expenditure required for fulfilling the said obligations forthwith without being constrained by the expenditure limit of 5 crores. And lastly, a bench comprising CJI Chandrachud and Justices J.B. Pardewala and Manoj Mishra today heard the petitions filed by State of West Bengal, the School Service Commission and certain affected employees challenging the recent judgment delivered by the Calcutta High Court. The High Court had invalidated almost 24,000 teaching and non-teaching jobs that were filled as a result of the 2016 SSC recruitment process. The jobs came under the scanner due to the infamous Cash for Jobs recruitment scam. The court today questioned if it was possible to segregate untainted appointments made by the West Bengal School Service Commission to teaching and non-teaching posts in the year 2016. Posting the petitions to next Monday for further hearing, the bench turned down the petitioner's prayer for a stay of the High Court's decision to cancel the appointments at the present juncture. However, the bench stayed the High Court's direction to CBI to undertake further investigation with regard to the persons involved in the state government approving supernumerary posts to accommodate illegal appointments and to take such persons into custodial interrogation if necessary. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.